Lane, you filed a speedy trial waiver in this case on June 14th, and I take it you're standing by that speedy trial as of today.
Yes, sir.
And you further filed a separate waiver on the same day signed by the client. Did he consent to that waiver with full knowledge of the time requirements that would otherwise apply?
He did, Your Honor.
And is that true, Mr. Lane?
That's true.
And you continue to stand by that waiver of speedy trial time today?
Yes, I do. Among other problems from which of which the defendant suffers includes visual and auditory hallucinations, which are brought on by light and sound and stress. In addition, Your Honor, for instance, he has been suffering from severe chronic migraines for years, and they are debilitating in nature, to the point where the scans of various sorts are necessary to determine whether or not there is in fact organic brain problem. There are organic brain problems, whether it be lesions or lobe development or other issues. All of those lend themselves to our defense, which we intend to present on behalf of Mr. Lane. However, additional testing is necessary, and that takes time. And therefore, we request until September, the end of September, to complete our testing and enter a plea of not guilty by reason of insanity.
In other words, you're asking the court to reconsider its order in this case, Mr. Devan?
Yes, Your Honor.
All right. Any response to that, Mr. Joyce?
Yes, Your Honor. May it please the court. The state of Ohio would agree that ample time is necessary for the defendant to look into whether or not an insanity defense is applicable. I do take issue with the fact that if Mr. Devane testifying on behalf of his client today that such things like hallucinations or those things have occurred, because there's nothing before this court or in the record that would show that to be true. And the only things that we do know is that prior to February 27th of this year, there has been no record or history of such things. However, in the fact that they are going to be testing their client and finding these things out, I would agree that September 30th would be a date, but I'd like that to be a date set certain with this court, that either they prepare and present the NGRI defense, or in the case move on, because the state stands ready, willing, and able to try this case. And if in fact they have their testing done at that time, we have psychiatrists online who are going to be able to review those records, and we would like to try this case as soon as possible on behalf of the victims and their families in this case.
We're adjourned.
Please remain seated. Thank you.